Well, ladies and gentlemen, good evening. Thank you for all turning up on time. There's going to be quite a few people drifting in. Try not to judge them. It is quite a long way across the river here, so you can get slightly wrong. Those who don't know me, my name is Rick Roach. I'm a shipping partner here at Northwest Fulbright, and I'm delighted to welcome you all, both in person and online, to this roundtable event organised by the London Shipping Law Centre. We hope you will all stay afterwards for things and a small buffet. And it's a shame that Alaka can't be here tonight. She, I'm afraid, has got a long-standing engagement in Athens. She is here in spirit, having set the LSLC up in 1994, and she will be with us in spirit. In addition to setting up the LSLC, she also set up the Young Maritime Professionals, and I think Francesca Campa is here. But anyway, she will say a few words just before the close of business to promote the YNP, and we're very supportive of that organisation. So about this evening, so as you can see on the screen there, the title is The New Anatomy of Maritime Legal Services: Collaboration, Innovation, and the More for Less Conundrum. It's my 30th anniversary this month of being at Port Rose, so 15 years over at Bishopsgate, 15 years here, which seems to me to be a startling lack of imagination. My colleague on the right will probably agree with that. But 30 years I've been here, and that's always been more for less. But that message has increased over time. People are, especially in-house, struggling with limited legal budgets, so they want more account fees and that sort of approach to life. The days of putting the timer on and letting it run long since gone. Sad to say, I'm sure happy in-house people to say. So anyway, tonight, three unique points about our debate tonight. Firstly, the topic itself. We thought rather than do something on substantive law, we think about the machinery for providing legal advice, how in-house counsel and the bar and law firms and other legal professionals and legal service providers, and of course we have to start thinking about technology providers in that category now, increasingly, how we provide advice to the maritime sector, both efficiently and profitably for those that are providing it. So there's those issues to discuss. You may have noticed from the bios that we had two people from Norwegian institutions here, which of course underscores the whole international element of shipping. And those who enjoyed or have survived London International Shipping Week a couple of weeks ago, I think what was amazing was the support we have from international bodies across the world. So the French were particularly supportive, sending a big delegation, Cypriots, all sorts of other nations supporting London as being a centre of shipping. So we're very pleased to see that. And then the three people who are sitting on the panel here have substantial in-house experience in commerce and industry. The role of in-house lawyers is changing as life changes. Political crises, regulation, an endless wave of regulation coming for shipping firms and requiring compliance and good governance. So we'd be interested to see how that is changing their requirements from big legal practices. So that's enough from me. We'll be back in a second, and I can now introduce you to Nick Webb, the General Counsel of Stolt Nielsen, who we all know as a region conglomerate providing transport, agriculture, and other things. And I will pass on to him to introduce the debate. So over to you, Nick.
Thank you very much, Brett, and thank you to Norton Rose for hosting us today, and all of you for attending. It really is appreciated. But it was kind enough to introduce me, but why don't I quickly let the panel introduce themselves? So, Marie, would you like to introduce yourself?
Yeah, of course. So I'm Marie Kelly. I am at Guard PNI Club. I'm the head of the defence team in London, and I used to be part of Shell's also a few years ago when I joined Guide.
Hello everyone, I'm Mo Farhan, I'm a barrister at 36 Stone. Amongst other things, I practice across a range of trial and litigation arbitration matters.
My name is Richard Firth. I now go under the label of consultant. Most of my working career was spent in-house at various institutions, although I ended up in dry dock with Linklaters for a period. I'm delighted to be here. Thank you for inviting me on the show.
Excellent. Well, let's go straight into the questions. Very quick sort of admin. The idea is there's Chatham House rules, so everyone in the audience can feel free to ask what challenging questions they like. I'll probably start off by asking the panel their views on various topics and then hand it over to the audience, both here and online, if that works for everyone. I was going to pick on our host first. I think it's always good to pick on your host when you arrive at a party. So, Philip, the first question that's come up on the flyer, and a number of people have wanted to interested in is, what emerging issues and challenges do you see for the maritime sector and its lawyers at the moment?
Yeah, so it is amazing to me how quickly shipping has changed. So for many years, I've been practicing, not much changed to be quite honest. Rules came in, but generally the way the ship operated, good and bad, kind of hadn't been changed very much at all. And then suddenly, with sanctions, with ESG and governance, D&I, suddenly we have this huge change. Regulation come thick and fast, which I think both private practice and in-house struggles to deal with. So, for instance, with sanctions, we went from 0 to full speed in a really very short period of time. I think the market is still struggling to find good sanctions lawyers who have experience and can give commercial advice. So it's not a question of understanding what the sanctions are, but it's very easy to, but the application of those to any particular situation, whether that's financing or carriage of goods by sea or the trade, is really quite difficult. And it is interesting that regulation now seems to be written for the purposes of the aim. So, for instance, if you are looking at sanctions regulations, it's not enough to look at the words, which lawyers like to do, and see what they actually say. Because if the government, in their rush, has failed to stop a particular trade or a particular transaction, judges will cheerfully fill that in for them and say, well, this is the aim of this regulation. It doesn't really matter that the regulation doesn't say you can't do that. Clearly, we don't want you to do that because it's a foreign policy aim, and so you shouldn't, and you are in breach of it. So suddenly, as lawyers, you're thinking, well, okay, it's not just the words, it's the practice. To find people who have that experience is proving to be quite hard. And we're seeing, so my practice, I'm a disputes lawyer. As I got older, I started off as a wet lawyer, having been in the Navy. I got drier and drier over the years, which is what happens to you. But now, whilst I am a disputes lawyer, I do shipbuilding cases, carriage of goods by sea, and all those good things, collisions and groundings. My job, particularly my team's job, is that. And my job is advising draft new regulations. So decarbonisation, energy transition, EU ETS, which of course requires not only understanding of the rules, but understanding and getting financial services colleagues involved, getting our Brussels colleagues involved, and trying to help shipping companies navigate this really very difficult area, which is going to cost a lot of money. And again, regulations, the EU is still talking about implementing regulations, and we don't know if the consultation ends this week. So we don't know how they're going to implement it to some degree. And then, of course, if let's say you have a French DOC and you want to have some strategy to deal with EU based in France, where your registry is, and you ask the French registry if the answer to some questions, they say, well, We don't know because we haven't written the rules yet. We haven't transcribed financial regulation onto these rules. So you have to all go away and wait. And of course, if you are a big chartering, say, trader, you want to start putting these things in place because it's coming very, very soon. And so it's quite frustrating for us as lawyers to say, sorry, we don't know what to say because we haven't written the regulations yet. So it is a different way of dealing with law. But that sort of thing, ESG is phenomenally difficult to deal with. E probably easier, but the social side, we've been helping a really good charity, Human Rights at Sea, to try to the Geneva Declaration with a number of firms. Reed Smith, for instance, we helped them draft that in the House of Lords the other day. Thanked for getting that through. When you delve into this, the terrible state of human rights at sea is quite shocking. And so this is a really useful approach. And then governance, sanctions, ethics, stakeholder governance, all those sort of things, which I think we'll probably touch on later, are things which here to try simple shipping lawyers. Try what?
Actually, but one thing I might add to that, from the in-house perspective, and I completely agree, trying to predict the future is particularly challenging in the regulated from ESG space. I think most shipping companies are going through the same experience at the moment, which is everyone's looking for new builds, and most yards out in Asia in particular are full, and your new build contracts you're looking at 26, 27, 28. If you're spending on average somewhere between 50 million to 100 million on a vessel, you want to know how you're going to fuel that vessel. And it certainly comes across my desk almost every week that, there seems to be ammonia could have been popular 3 months ago. Last month it appeared that it was wind power all of a sudden. And it's very hard to plan for the future and to build such expensive machines when you're looking to do 10 to 20 a year. And I don't think we're alone in that space. If you can't predict how you would expect it to fuel those in 5, 6, 7 years, I think that's a particular sort of practical challenge, not just we face, but I know General Counsel's got a number of the shipping companies are seeing as well.
And the banks are worried because they don't want to have stranded assets. They don't want to lend a whole bunch of money to people who go and build, say, ammonia ships, and then find that actually we've never ever hoped to build the bunkering infrastructure that you need to run these ships. And so these things aren't as paid. So it's not just you guys, it's banks
And insurers. I mean, who's going to be the first to insure the first ammonia powered vessel?
Who are insurers?
You have to talk to us already. So it does affect us as well, and the whole increase in regulation affects us too, because of course we've increased. We have a huge sanctions team now because we have to look at the effect of sanctions on us. Not our members have their own lawyers. We have to look at what we can cover, and that has really taken a lot of time. And we've expanded the team, and there's a lot of knowledge in the house now on sanctions. So I think everyone is spending more money on regulations, no doubt about it.
Well, Richard, was there anything you wanted to add?
Just one point on the issue of sanctions. I mean, my own experience as agents, to speak on what Philip said about companies trying to deal with sanctions or the regulations aren't in place. My own experience is even when they aren't in place, you can't. It's not really feasible, viable in most situations to go to an agency like OFSI and say it's a potential sanctions issue. They can give us guidance one way or the other. It's not something they're set up to do, not something they're really prepared to do. So there is a real reliance now on accumulated knowledge, but there is ambiguity because we have to rely, as Philip says, on sometimes purpose of interpretation of these regulations. But I'd be interested if anyone has any experience of getting a more definitive answer out of anyone on these issues.
And Nick, I was going to say one article which I read in City AM about a fortnight ago, written by a partner at Holmes, was that criminal liability under the new the bill or statute is being extended more to companies. So that I think will have an effect on how seriously people take sanctions.
Well, the next question might be quite a helpful segue into who would move to the dark side and go to a corporate? And maybe at the back comment, none of us, although I say that as a general counsel, that's a corporate, but maybe I'll ask Marie to comment on why move to the dark side.
Well, I have to say that I did laugh at this title because I think we're following the light. I don't think we're crossing to the dark side when we go in-house. So I jumped at the chance of saying a little bit about this because I've really done quite a few different things in my career. I started off as a Scottish solicitor, and then I came down to London to be a competition lawyer. And then I went to the bar, and after being at the bar for 6 years, I had married a Greek, and he wanted to go to Greece for a year. And so I talked my way into the Greek office of Norton Lisbon, right, and stayed there for 20 years. So, and then when I became a partner, I had to become a solicitor again. And then in 2020, I moved to in-house to Guard, to P&I Club, having been in the maritime industry for years. And I have to say that, when I started out, I think it was more unusual for people to move from private practice into P&I clubs. But things have really changed. When I get inquiries from very senior people about jobs, and if I ever advertise a job, I get, loads of people applying. Some of them, really senior lawyers from private practice. And so, in order to give you some hints and tips, I thought, let's think about, what's driving this. And I think there are several factors, but I think that the first factor is the kind of tyranny of the target of billable hours and billable amounts. Because I think that puts a lot of strain actually on associates because they have to meet these targets, and in addition they have to do in-house provision of knowledge, external provision of knowledge. No one has any secretaries anymore, so they have to do a lot of admin. And the whole thing, it becomes that you're spending so much time in the office that you really have no work-life balance. And then it does look more appealing to go in-house. And then there are other things about the direct connection with the client. So when I was a partner in a law firm, the clients all wanted to see me. But now I'm the head of a team of defence lawyers. The clients aren't interested in me. They want to see the lawyers. They want to see the lawyers who are handling their insurance. And that's a great thing for a lawyer because they want to have that direct contact with the clients. They want to be dealing with their business. They want to know what they're doing in their business and to be really important to them. You definitely get that in a P&I club. And you're at the coalface, so you're dealing with issues, all the issues that you see in the shipping world, and you're dealing with them when it happens. I mean, by the time the lawyer gets it, the dust is settled a lot of the time. But when you went to P&I club, you're getting it as soon as it happens. And that's actually quite appealing to a lot of people. And then there's the other thing, which is I think it's probably becoming more difficult to be an equity partner in a law firm. And I think that's down to the more for less challenge. So everyone's looking for capped fees, everyone's looking to have reduced bills, and yet the law firms are also looking to make more profits per year. And in fact, there's a kind of ranking. So the law firms where they make the most per equity partner, are seen as being the best law firms. And how is that sustainable? It's only sustainable if fewer people get equity partnership. And then, if you're slaving away there as a senior associate because you think you're going to get partnership one day, and it becomes clear to you, this is becoming less likely, then you're going to be looking for other things. I have to say, there are other things about being in-house, because you're at the coalface, there's a lot of pressure. So you're really pressurized during the day to make snap decisions, to make judgment calls, and that's not for everyone. And the other thing I would say about going in-house is that there's a much bigger range in the kind of experience you might have as an in-house lawyer in the shipping world, because it's very different to be an in-house lawyer in a P&I club with a team of lawyers. I mean, we've got 50 lawyers worldwide, 17 lawyers in my office, from being perhaps a sole lawyer working for an owner's team or a management team. That's a different thing. And so if you're thinking about going in-house, I think the first question is, what's that like? What's the support? Is that going to be better than my job in private practice? What are the advantages and disadvantages of each? So I know that Philip is going to take issue with everything that I've said.
I'm surprised when it's described going into the dark side. Practice with the dark side. I mean, I hear all that. I mean, it is not as awful as the Green hate. I mean, you made the decision to go.
I wasn't trying to do yes, we can't get that bad.
And there are firms and firms. I mean, we have a firm like this, which I can't remember if it's the 8th or 9th biggest firm in the world. We are huge. It's working for a very big entity, and as a shipping team in London, you feel quite small and powerless. But we have friends across the world. And we've got a good network, and so it is a day job. Working with young lawyers, dealing with all sorts of issues, dealing with litigation. It's good fun. I think couple thrust of litigation is something which is worth doing. I couldn't possibly do asset finance. I have no idea how those people get through the day, but certainly litigation is fun, and advising on regulation is different. But I think it is as you say, it's 22 years, not all that.
No, that's certainly true. But the other thing is that because people are looking for value for money, what they're looking to do is to recruit lawyers who will come in-house and who will do a lot of that work that lawyers in private practice used to do. So they will take the case to a certain level. Then, they probably won't have the resources. They'll have to go out once a case gets to the stage of, past claim submissions. But I think that that's going to be an increasing trend.
Richard, if you would. Any comments on being in-house? You were guilty of hiring me in-house, so you must have something to say.
I think when one's in private practice, one's in the front office, and to be in the front office is always an advantage in any position. For instance, in the major firm where I worked, there was sort of 24 hours typing and word production on call. That's something you won't get in-house. I think a major differential between working in private practice and working in-house is that as an in-house lawyer, one tends to be part of a multidisciplinary team. And I very much myself like discussions and applying on context. And that's certainly something which is very strong. Another point I would make is that many people have commented that in-house lawyers tend to be fairly happy lot. And for instance, this book I've got on the desk at the moment, Tomorrow's Lawyers by Richard Susskind, he comments that some of the most satisfied individuals he's met in a professional sense happen to be in-house. In-house departments, of course, vary in size, from relatively small to enormous. Citibank, 2,000 of us. One thing which in-house departments don't do is knowledge management, whereas public practice does that and does that very well.
Perhaps we'll ask a fresh question. So, Mo, is the perception in any way correct that members of the bar and arbitrators are resistant to change? Do you have any comments on the latest developments in this respect?
Thank you again for the invitation to speak, to Monty for hosting. I think hopefully you see the question behind me, and I think it was a rather loaded question to speak to. I'm going to assume, without making any admissions, that there is in fact such a perception. The question then is that perception correct? I think in many respects it's quite an opportune moment to deal with that question because we are in a time of great change. We've heard already from the rest of the panel about that are happening in the industry. I mean, on the more substantive front, we've got a number of developments. Just last week, we had the Electronic Trade Documents Act come into force. And of course, as anyone who's been on the seminar circuit recently knows, this was the ongoing reform to the 96 Arbitration Act. That's what I thought I'd focus on and look at this question through that lens. And I thought the way I do it is as follows. I'm going to focus and look at one of the key proposed reforms that's being put forward by the Law Commission, and one of the key proposed, what I call non-reforms. It's one of the decisions that's made by the Commission not to pursue reform. And I want to look at the role played by members of the bar and the arbitral community in pushing through or dealing with those consultation proposals. So the first topic I want to deal with is the law governing the arbitration agreement. Anyone who's looking at this topic recently would have seen it's the most headline-grabbing reform proposal that's come out of the Commission. It's the proposed introduction of a new default rule that unless the parties agree otherwise, parties' arbitration agreements to be governed by the law of the sea. And that's a departure from what the Supreme Court said in England, although not necessarily inconsistent with it. And this isn't the time or place to deal with the merits of reform proposal, but what is interesting is the role that both COMBAR, I say COMBAR as reflective of at least part of the commercial bar and views it holds, and arbitral institutions such as the LMA played in pushing that reform through. Because what's not immediately apparent and what's striking is that actually this proposal was never on the Law Commission shortlist to deal with in the first place. It didn't feature in the first consultation paper, it was sort of inside. And it was only the responses from COMBAR and the LMA that really brought this to the fore. So I think that in itself is indicative that there isn't necessarily a resistance to change. In fact, there can be a dynamism when called for. I mean, the COMBAR response, I mean, it's available on the Law Commission website, it's worth a read, but it's quite robust in proposing reform on this topic. The LMA is similarly sought reform on this topic, although it was more concerned, I should say, by the impact of the ENCA decision on its own terms rather than any more general concern about the state of the law.
Is that the LMAA?
Yes, the LMAA terms. So for those who don't know, there is a provision in the current LMAA terms that provides for a default rule as to the law governing the arbitration agreement. There was a concern given on the part of the LMAA, given the way that rule was drafted, whether the decision in ENCA would lead to upsetting that default rule. That was one of the reasons they gave for supporting reform. Again, I don't want to get too much into detail, but I bring those two examples up as examples of how the bar and the arbitral community, effectively COMBAR and the LMAA as representative examples of those two communities, have actually been driving forces for change rather than resistance to change, as the question behind you would have believe. The second topic I want to deal with is what I call non-reform. Again, this has been a hot topic given drives in our profession, in the arbitral community in particular, to increase diversity and to do more to ensure equal representation in terms of arbitral appointments. So, and that's the topic of discrimination. Now, unlike the situation with respect to ENCA and Chandler, the default law governing arbitration agreement, here discrimination and proposals to reform how the law of discrimination applies in relation to arbitration did in fact feature in the Law Commission's first report. And the proposal was that any terms agreed by the parties, some very general terms of the proposal was that any terms agreed by the parties that provided for the appointment of an arbitrator on quote-unquote discriminatory terms. So on the basis that they should or should not have a certain protected characteristic would go enforceable, unless that wasn't pursuant to a proportionate legitimate aim. And there's a whole host of problems that gives rise to, in our industry, we're very familiar, although they come on more by way of anecdote than practice, commercial bank clauses, for example. That's a very common example that comes up in discussion. But even outside of sort of work that this audience deals with day to day, religious arbitrations, there's all sorts of different arbitrations where this might be an issue. Again, this was a topic on which both Colbar and LMA expressed a view. Interestingly, on this point, they reached different views. Colbar took the view that there was no reform. And interestingly, the LMA didn't really take a view, just said agree in response to the question. The point to draw from this, and I think it would be wrong to take from this example, and I think the bar and the ultra community have been criticised on occasion for not doing enough to support more equal representation and more equality of opportunity in terms of diversity. I think it would be a mistake to take what's happened in the context of discrimination as an example of resistance to change. I think if you look at what's actually happened and the proposals that were put forward and the way they were responded to, it's actually more, in my view, indicative of quite a nuanced debate between those who are consulting and those who are providing their consultation responses. I think it would be dangerous to form a general perception that there's a resistance to change simply because this particular proposal hasn't gone through. I'm going to stop there because I've gone over my time, but again, I just wanted to, obviously I raised these 2 points by way of example, but I'm very interested in hearing from the audience whether there's any other examples that people think are supportive or not supportive of this perception.
Have you already sort of view on if the bar is or isn't resistance to change?
I think a critical response to what you've said about our arbitrators resistant to change was what happened in the pandemic when overnight people were unable to go to the office, and it could have had a major impact, for example, on cases before the High Court and before arbitrators. And I think the reaction in London is just amazing to that situation because the Commercial Court made it very obvious that they were going to be resistant to anyone applying to adjourn arbitrations on the basis that they weren't ready because they couldn't have them heard remotely. And the LMAA did exactly the same thing. So if the theme of this discussion is about what can be done in terms of collaboration with the industry and the legal services industry to respond to things such as that, I think that is a very good example where the bar, the High Court, and the arbitration community responded in a quite magnificent way to this crisis. And I don't think that there were very many cases, if any at all, which were put back as a result of that. So I almost bridle at the suggestion that arbitrators are resistant to that change. And I'm not talking from personal experience because I actually retired from HFW immediately it has happened. So there's no question of me being in that situation and slapping myself on the back. It was the guys who were already in that position, whether the judges, I call them guys, but the judges or the arbitrators in that position. On the question of diversity, which you were just addressing, the president of the LMAA is really responding to that in person at the moment, and he's going out and speaking to potential arbitrators who are, say, 8 years away from retiring, who could be potential people to come forward. And amongst those people are obviously they're looking at diversity question, not just people in London, but overseas as well. But of course, obviously, as a matter of female arbitrators. And I mean, if you look at the full members of the LMA at the moment, I think 6 have been made up, female arbitrators have been made up in that regard. And of course, what the LMA often says in response to this is, well, we don't appoint the arbitrators. It's for the industry to appoint the arbitrators, and they nominate the arbitrators. But insofar as they can put up names and encourage people to come forward, they are very much doing that. So that's my response in relation to the resistance to change, speaking on behalf of the arbitration community.
Can I just say something on that? I mean, I know I hear what you're saying about diversity, and it's true that there are no women participants. But because the LMA doesn't, because they say it's private arbitration and they're not really an international organisation. On one hand, they say they're an international arbitration organisation. On the other hand, they say, oh, it's just private arbitrations. You've got no statistics about diversity on arbitration tribunals in the same way that they have in the ICC. And I would say that if you really want to do something about diversity, the first thing you have to do is address that and look at diversity in arbitration tribunals. And what is the actual diversity? So I mean, I acknowledge that things are better than they were. Still a very small percentage of female arbitrators. And, you know, it's kind of very predominantly white male. And I, for one, I'd really like to see that change. And I think that clients would like to see it change too. So I do feel that there is, and one of the problems is there's such a small group of full members of the LMAA. And we all know we're in the shipping world. A lot of arbitration is done in the LMAA. And that clients kind of want to appoint a full member because they feel as though that is more of an endorsement. I realise there's a huge list of supporting members, but the full members, the diversity of the full members is, well, it's not great.
Can I answer that? I mean, first of all, the LMA is not an institution. It is an agglomeration of practicing members. So it's not an institution. It doesn't choose, and that's the point I've made already. I think from my limited experience, because I've only been involved in it in a very short space of time, is that they are very aware of the points that you have said. I take on board the point that there may not be any information about the makeup of the tribunals, but there are something like 36 full-time LMAA members, of which I'd say 20% are female at the moment. And obviously, you've got to start somewhere. So it's good to have this discussion openly like this, and someone in your position as the head of the defence of one of the major P&I clubs to be saying what you're saying. But I also know from my time in the legal community that there was a group of law firms. Norton Rose was one of them. HFW was another. There are 6 or 7 firms probably represented here, where we held evenings where it was like not hot desking, sorry, speed dating. And we encouraged, and I think one of the sessions was here in this room.
Was I was here.
Because I came to it and in support of the female arbitrators. So, you know, it comes from both sides. It's got to come from you appointing people as much as from the non-institution, as I may call it, as well.
Could I please just ask a supplementary? One of the questions which we received prior to this evening, someone was perceiving that arbitrators were really in 2 classes. There were people who were the former members of the judiciary, one level, really respected, and then LMAA members, perhaps less slightly regarded. Is that a fair comment, do you think, or not?
I think it's invidious for me to respond to that.
And where was at the Chatham House rule, so you can.
Well, it's horses for courses. I mean, as I said, I spent 38 years appointing arbitrators.
Yeah.
And I was very aware of the type of dispute you want, whether you want a legal, a commercial, a technical guy, or whether you want a member of the judiciary. I can speak from personal experience that 1 or 2 nominations I've had where I'm on a tribunal with a member of the judiciary, it's been fantastic having someone with that depth of knowledge, and some of them are so user-friendly. I've heard adverse comments about members of the judiciary as well. So really, it's for the user to nominate who they want and to know who they can possibly use.
In other words, it's market forces that determine who becomes arbitrators, who's selected.
It is, yes, it's in one respect, it's a commercial transaction in as much as you say it's market forces. I come back to my point, who appoints the arbitrator? It's the party. It's no one else.
I just pick up on that point. I think because for that reason, there's a lot of force, I think, position the Law Commission's come to, which is this is not an area in which it really is necessary or desirable to legislate, because it's not really a case of parties agreeing provisions in their contracts that are discriminatory, but it's parties potentially being discriminatory in the appointments themselves. And that's the point I think that we're all have to take some responsibility for, any of us who play a role in deciding who's to be appointed to a tribunal. That's not a self-responsibility. It's not necessarily, I think it's the view, it's the view of the Law Commission, which is not bad for legislation.
Can I just say one more thing? It's not actually entirely correct to say that the arbitrators are appointed by the parties. There's a very important role, which is when two arbitrators are appointed, they often appoint the third. And that is a way in for new arbitrators. And I would like to know, what are the statistics on that? How many women are appointed as the third by those two arbitrators? I'd like to know that. And then there's the other statistic, which is there's arbitrators that are appointed by the president of the NMAA. You would hope that some efforts would be made to encourage more diversity in those appointments. So it's not quite so simple.
Well, I was slightly worried when I saw the list of topics, we wouldn't get a lively debate, but seems to have cured that. Thank you, that was a pretty helpful contribution. Thank you very much. Gone down most of the list now, but I'm conscious that Richard in particular has a huge amount of experience in the education and legal sector, and I think it'd be quite interesting to hear his views on whether we think there's effective training, particularly in the maritime legal sector at the moment or historically.
That's very kind of you, Nick. When I was preparing my thoughts for this evening, I felt a bit daunted. But then I thought of David Cameron's famous quip, "I was the future once." I suspect that many of us, and particularly myself, have mixed motives for being at this London Shipping Law Centre event this evening. We've come to sample Norton Rose's buffet and drinks, which I'm sure will be excellent. We've come to pleasantly meet up with members of competing chambers and firms at a neutral venue, rather than in adversative context. From one point of view, I suppose it is a bit like speed dating, though that didn't happen in my life. And then the third reason perhaps for being here is to have, as a leading lawyer, Philip Wood, ACCB, put it to me once, a gargle at the fountain of knowledge, and thereby, at the minimum, fulfill certain mandatory post-1980s CPD requirements. Incidentally, I was on the committee of the Law Society that recommended this. Who could hold me responsible. I think that you will agree with me that a vital living organ of the anatomy of legal services is post-qualification competence. I have therefore pulled together for your consideration a potted history of the steps taken to assist legal practitioners in keeping at the forefront of knowledge and expertise. I'm going to call this segment 1949 and all that. Why choose 1949? Because in October 1949, there occurred a revolutionary event. Sir Alfred Denning, then a Lord Justice, broke with the strict convention of the time that judges did not speak extrajudicially. And Sir Alfred Denning gave the first and thereby groundbreaking Hamlin lecture. Now we come to the first plug of the evening. The Hamlin lectures are now in their 74th year. The London Shipping Law Centre is immensely proud that our President, Lord Thomas, is giving the latest series starting next month. His topic is laws for a nation and laws for international commerce. Where is the line to be drawn? I'm looking forward to his comments, and I suspect he may well draw on the Financial Markets Law Committee paper, which was put together with his able assistants. The date for the London lecture, which is being held at the Guildhall, is Tuesday, 7th of November. And if anyone's interested in it, tickets can be obtained from a lady called Katie Foster at cityoflondon.gov.uk. And if anyone would like it, I can ask Gerald to send around that email address afterwards. When we're talking about shipping, of course, mention should be made of the prestigious Donald O'May lectures delivered under the auspices of Southampton University's Institute of Maritime Law. The date for their 41st annual lecture is Wednesday, 8th of November, the following day after the Hamlin lecture, and it is to be at the Law Society's Hall in Chancery Lane. The lecture is going to be given by Sir Nigel Tier, the former Admiralty Judge, and I understand the topic will be ship collisions, although the title is still being finessed. Anyone who wants information on that, the email address is iml, Institute of Maritime Law, or it's iml@soton.ac.uk. The next year which I would highlight is 1974, which is when the Lloyd's Maritime and Commercial Law Quarterly was first published. The LMCLQ is highly significant in its contribution to the dovetailing of academia and commerce. The recent case note on the 2022 Court of Appeal decision, now on its way, as you probably know, to the Supreme Court in March next year, and it was about mirror shipping against IUR, well illustrates the point. And the case note is by Professor Peer of Oxford. It's called Overcoming Force Majeure by Reasonable Endeavours. It's fair to say, I think, that Professor Peer is on the side of the appellants. The final period I talk about is the early 1990s, and they were a key period, and there were two drivers. The first was to make practical legal knowledge available to us as a profession as a whole, rather than being the exclusive preserve of some city firms, which I think Clifford Turner was particularly. Anyway, the leading exponents of making knowledge more available were three, I suggest. James Lingard of Norton Rose, who made tremendous contribution to finance, domestic finance. Philip Wood, ACE, CVE, some of whose early presentations actually gave at the Paterson Law Institute of New York, and they were on shipping. Philip's, another plug, latest book came out this year, worth reading. It's on choice of law. And then another key proponent of change was Richard Ewart from Slaughter and May. He was the driving force behind the magazine, which is pretty highly regarded, Practical Law for Companies. Some people prefer LexisNexis. Probably LexisNexis goes into more depth. It's fair to say that Norton Rose continues the tradition of making knowledge available to us all with their partner, Professor Richard Howman, who very eminent editor of one of F.A. Mann's books. F.A. Mann was someone that Norton Rose extremely. A second key driver was the appointment in solicitors' firms of professional support lawyers. Now they're better called knowledge lawyers. They've become increasingly significant, and I think they now form a part of the mainstream of firms' infrastructure. It is they who are behind many of the law firms' talks and briefing notes to clients. And certainly, when I was preparing the Financial Markets Law Committee report on good faith, we would draw on knowledge lawyers, including knowledge lawyers for the law firm. Finally, we get to the London Shipping Law Centre. You'll be glad to hear I'm about to finish. Finally, we get to the London Shipping Law Centre and the young maritime professionals. There is a saying in commerce, what gets you here won't get you there. But both organisations have, in my opinion, exceptionally strong leadership, and both will continue at full steam ahead.
Richard, that's very interesting. I think we're probably just about out of time to cover the relating topic, which is how effective collaboration and innovation can help meet a commercial imperative of value for money. I might ask Philip for a few comments on that, if that's okay with you, Philip.
Sure. So I'm going to back all this into, if you don't mind, kind of intuitive. So one of the answers which we are talking about the whole time is that technology is going to come like a knight in shining armor to our rescue. Suddenly, we're able to use ChatGPT and technology and machine learning. It will do away with the drudgery of disclosure and admin, and we'll all be able to focus on adding value and doing good stuff. And we need this. Richard was very kind and sent us all a copy of the document there on the desk there, Tomorrow's Lawyers, which my children found hysterical given my age.
Tomorrow's Lawyers by Richard Susskind, Casey on and OBE, third edition, worth reading.
A whistle-stop tour through how our lives can change. And as I sat on the phone this afternoon and tried to explain to a client why the bill that we sent him last week was so totally wrong, it made me think that actually my job hasn't changed very much in the last 20 years, despite this huge investment that Northern Rose has made in technology. And there is a lot of hype about this, how it's changed the world, and how if you're not engaging right at this very second, you're going to be left behind, and life is going to change, we're all going to be obsolete. And I would say, from our perspective, as a firm that is working quite hard to think about how we can use technology to deliver a better result for our clients, for in-house lawyers, it has a role. So, for instance, we have a client that is really struggling dealing with risk in numerous jurisdictions across numerous sectors. They don't seem to be able to get enough lawyers to just deal with it. Things get missed, they make mistakes despite their best efforts. Technology is a way of helping them deal with that. Bringing the information together in the central repository so that they can look it up and they can have access to it. And that's all great. And that works really well. But to do that without using fast technology is very hard, because to try, anybody who knows about trying to keep a database up to date, is that unless you really, really try hard at it, it starts to become stale. One of the reasons that the bill that I sent to the client, that was so wrong, was because of the data that the system had on it, which was not too right. And so I found myself doing what I probably wouldn't have done 20 years ago. Because 20 years ago, I wouldn't have relied on data. I'd have everything else that I'd have got it right, and I would have sent the bill out, and it was great. So I'm sitting there thinking, well, technology hasn't really helped me a lot. And people talk about AI, and there's, you know, these fabulous things, ChatGPT, which, if you read about it, because of algorithms, because of what programmers, how programs have written these to try to make you happy, to give you what you want, because of the data they're using, they hallucinate. They hallucinate and they fill in the gaps where they can't find an answer. And so there's a fabulous case about this poor guy who fabulous looking issue to an American court. The other side had to point out none of the citations in it were real. And the person who'd asked ChatGPT to this to save time, save client money, had actually asked the search engine of ChatGPT, are all the cases that you have referred to real? And the answer was yes. And none of them were real. And we think, you know, we have a committee which thinks about how AI is going to be used. But the problem is that the old adage, data, sorry, rubbish in, rubbish out, is absolutely applicable to AI as this else. And so unless you can put your hand on your heart and say, all the data in this database is good, then you are running the risk that what's going to come out is going to be quite right. So people say, oh, but you can fix that by putting a human in the loop. And that is absolutely right. But I would just say to people, technology, I think, will help us and does help us all the time. So, for instance, you know, disclosure. When I started disclosure, it was an awful thing to do. Now, you have search terms, it all gets filtered, you have a team, and it's all used to be manageable with a vast amount of data, but it's now manageable and, of course, convenient. You do it online, you do it at home, you do it in your council, wherever. That really works well. So that is saving people money and time and misery of that task. And all sorts of things. So we've just been introduced as a proofreading program, which we now apply, and it's a bit of machine learning. So not only is it check spelling mistakes, but if you define the term bank, one part of the document, it will have a look and see where else you use that and tell you if it doesn't seem right, if it's not capitalized, if it's wrong context, or or whatever. So, you know, poor solicitors spending hours and hours proofreading documents, that's gone as well. So there are real improvements technology can do, and I'm all for it, and it's important we invest in it. I think if we do that, we can give, like you guys, a much better service at a better price. But let's not get ahead of ourselves. We're not going to do ourselves out of a job anytime soon. We're going to need humans in the loop. We're going to need good training, people who can come in and actually be the human in the loop, make sure citations in the descriptions are correct. Yes. So I think technology is the way that we solve that problem, and it's great, but we're not actually at the stage where we can just, I can put my feet up, and I think the phrase is earn while I'm sleeping.
I was thinking that's
Not quite there yet.
I sometimes wonder about asking law firms, and as a general counsel, for technical solutions. If I'm asking a law firm, like a turkey, to vote for Christmas, what do I mean by that? Because in the end, if you find an amazing technical solution that will save you time with your 1, 2, 3 year qualified associates spending hours and hours proofreading, doing disclosure, doing due diligence in a data room, you're going to be charging a lot less money. And I sometimes wonder, why would that turkey vote for Christmas? But I'm not suggesting you're a turkey for it, but I do think I do genuinely think there's a slight conflict there, and it doesn't surprise me if you ever go to one of those conferences that are targeted at general counsels. I think about 80% of the attendees are technology firms, but generally trying to sell me some product that I have to be honest, I completely don't understand and won't pretend to otherwise. But I do think it's a really interesting conflict there. I did actually, we do a lot of M&As, I'm sure a lot of in-house counsel do. I did actually see quite a really interesting program recently that deployed a version of ChatGPT where you put a document due diligence for a spoof company basically into a machine, and 2 hours later it gave you a full due diligence report. And I think they were still working on the modelling of that, but that is interesting. If I spend $1 million on a due diligence buying a potential company and it can spit us out like that, obviously, to your point, it needs to be reliable, and that's the key. But It'll be interesting to see how that sort of technology develops. But no, it's certainly a challenge that I think it's going to face us all. I can almost smell the buffet outside, but I'm conscious we haven't let anyone ask a question substantive yet. Please. Oh, yeah, please go for it.
One comment on the AI. Our US PI insurers are over in London, no doubt visiting all their clients. And they gave a presentation to staff on common mistakes, things you should do to avoid claims. And there was a whole section devoted to AI, the essence of which is do not rely on it. Use it by all means, but do not rely on it because it gives rise to a significant number of claims.
If I could say there's another thing that's very useful in technology, we invest with AI. You were sitting on a huge amount of data about claims that are going on across the world. And now we're all looking at how we give the members access to that data so they know the dangers of agreeing to charge a party to that particular court. And if they're going to go there, they know that the pilots aren't very good. Perhaps they should think about that. Or they know that there will be a cargo claim there. And that's a very, very useful use of technology for our Crown members. And the law firms as well, they have huge sources, a huge source of data that could be used to help their clients. And that's kind of taking a step back from AI. So it's looking at how we can make that data available so that it can inform choices made by clients. And that's quite an interesting topic in itself.
Spotting the patterns. So only the technological solution can do that. So massive information goes in and pops a risk. No,
Exactly.
the end actually risk.
Anybody else in the audience or online, if we can have online questions, anything you wish to ask?
Let's add something on this AI point. I do think this is somewhere where we are really feeling our way as we go. There was something in the press, I think last week, when Lord Justice First admitted that he used ChatGPT to write part of his judgment in the Court of Appeal. And he explained that on the basis that he asked to summarize an area of law with which he was very familiar. The output was accurate, he took responsibility for it, and he thought that was perfectly acceptable. I mean, that is a completely unexplored terrain, the use of AI to draft bits of judgments and even harmful awards. So what's the space, I guess, to make the first drafts?
Yeah, first drafts.
Excellent. But I think that just leaves me to hand over quickly to Francesca Capper, who's chairperson of the Young Maritime Professionals, who's behind you, going to say a few words. Can you hear us, Francesca?
Yes, I can. Can you hear me?
We can, yes.
Yes.
First of all, on behalf of the London Shipping Law Centre and YMP, I would like to thank all the speakers, and in particular Richard, Philip and Nick, for putting together such an engaging and insightful event, examining the future of the maritime legal services sector in this such-called post-pandemic era. And a special thanks must go also to all at Norton Rose for hosting this event and making it possible. I must say that what struck me most is that probably 1 or 2 generations ago, it was not uncommon for shipping professionals to join a firm or a company and stay there for their entire career. And nowadays, yes, shipping is certainly an industry where loyalty is important, but thanks to the technology, we as youngsters are, I think, very, very fortunate. We have tremendous diversity of paths, and we can follow different routes for our career, and we can perhaps decide how to work in a flexible way and how and where we choose to work. And I must say, I really enjoyed that personally. I have moved in-house and, I am benefiting from the technology. I'm working completely remotely, so I am definitely one of those people who benefited from the pandemic and the change. And so I thought this event was really, really interesting. And so thank you very, very much. And I'm sure all of us attending have found the information, informative, and will benefit from the vision of the future that have been outlined this evening. So from the LSLC and YMP and myself, thank you very much to all the panelists, Norton Rose, and all the attendees. And I wish you a very pleasant evening.
Thank you, Francesca, and thank you everyone for attending. That's a wrap.
I just very formally apologise to you for an attendance which is not as great as we might have wished. But I think it's the first time in 30 years that one can simply say it's the fault of Tower Bridge getting stuck. And I know that about at least a third of the audience here have been very delayed in getting back here. And we must also assume, I think, that a number of people who would have come here are on the very simple basis that there are a lot of lawyers north of the river who couldn't get south of the river and would have said, I'd give up.
So still
sorry about that.
Sorry.
That's all we stuck.
Thank you.